Yes. Hey. Oh yeah, I'm here. Oh yeah, yeah. We just had a problem down there. We were trying to get.
That's it.
Motion to grant code purpose.
Your Honor, as a threshold matter, we would like to suppress the evidence in this case, and we assign the following grounds separately. First of all, this was an unwarranted search. There is not a search warrant in this case. This was an invasion of this citizen's home without a search warrant. Every search by law is deemed to be illegal and unconstitutional. And before we begin the trial of the case, I suggest that the evidence should be suppressed on the grounds that the search and seizure violated the Fourth Amendment of the Constitution of the United States, as well as its state constitution counterpart. And we'd like to be heard on that. As I said, every search is presumed to be unconstitutional. Once a defendant injects the issue of the constitutionality of the search into the case, then the burden is upon the prosecution to show that, in fact, the search and resultant seizure were, in fact, unlawful. So now, this is the city's turn to deal with it.
Judge, if you want to approach this as a hearing on Mr. Lackey's motion, the testimony will be largely the same as testimony at trial, but the officer's here and he can tell us about the facts and the exceptions of it. What Mr. Lackey's talking about.
Well, yeah, we're here for trial today, and I'll take your motion under advisement, Mr. Lackey.
Oh.
But I think for me to rule on the motion, I'm going to have to hear some evidence or testimony from one side or the other about how this search was unwarranted or exactly what occurred during the search.
I understand, Judge, but I think that the way that all the courts I have experience with at least do this is to take up the motion to suppress initially. I don't think we'll get past that motion, but if we do get past that motion, then and only then should there be a trial of Mr. Crow. So I would like for the city to put on a showing of how they contend that this invasion of this citizen's home without a search warrant was lawful.
Well, for the time being, I'm going to deny your motion. We're going to proceed with the trial, but I will keep it in mind, and at the appropriate time, if you want to remake your motion, I'll be glad to take it under advisement at that time. Please call your motion.
Judge, for the record, I would like to object to the procedure that is being employed in this case. It is unlawful to proceed with the prosecution of a criminal case in the face of a motion to suppress the evidence. That is unprecedented in my almost 30 years of experience as a criminal defense attorney. I have never yet seen a court proceed to trial in a criminal case in the face of a motion to suppress, and without taking up the motion to suppress, having a hearing on it, and ruling on it. And so we object to being put to trial with the pendency of that motion.
Your objection's no.
And I take it it's overruled.
It is.
Okay. We would like the rule invoked, Your Honor.
If anybody in the courtroom who is a witness in the Garrett Patrol case, I need you to identify yourself and step outside into the lobby, please.
So witness, Judge, you can...
No, sir. Hold on. Anybody else? Go ahead.
Did we call Officer Dale Manning?
Officer Manning, you stand and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Consider yourself under oath.
State your full name, Bill, for the record, sir.
Emmett Delmain,
How are you employed, Mr. Manning?
Scottsboro Police Department,
How long have you been employed with Scottsboro PD?
6 years.
What are your primary duties with Scottsboro PD? What have you been for the last 6 years?
Canine officer and housing authority,
Canine officer, what?
and housing authority officer.
Through your duties with Scottsboro PD, did you have occasion to come into contact with Garrett Allen Patro?
Did,
When did you have occasion to come into contact with him?
1/7/09, January 7th.
What were the circumstances that you had in contact with Mr. Patro on that day?
The traffic stop,
Where did the traffic stop occur?
328 East Maple.
What was the reason for the traffic stop?
Improper muffler.
How did you determine the muffler was improper when you made the stop initially?
It was extremely loud and there was smoke coming from it, clouding up the road.
That 328 East Maple Street address, is that also Mr. Patro's home address?
It is.
When you stopped Mr. Patro for the muffler violation, did he produce his ID or driver's license for you?
No, he said it was inside.
Inside his house?
Yes.
Did you allow Mr. Patro to go inside to get the driver's license, or?
Later, not at that moment, I did.
Okay, what did you do next after the stop?
I asked him about if there was anything illegal in his vehicle.
Okay. Did he indicate there was not?
Judge, we're gonna object to any information or any evidence being offered, as far as a response to the question whether there was anything illegal in his vehicle. That constitutes some sort of question or interrogation within the meaning of the Miranda case. There's been zero evidence that this defendant was Mirandized before he was interrogated by the officer. Basic criminal procedure is, if you're gonna ask the target, object, or subject of an investigation or a traffic stop, those kinds of questions, then you should Mirandize them first. That was not done. There's been no showing of that, at least. So we object to any answers to any questions until the proper predicate is laid.
Was Mr. Patro under arrest when you asked him? Was he detained?
No.
Was he
He
free to
was
leave?
detained until further, investigation of the muffler and get his ID and everything.
So by definition, there wasn't a custodial interrogation going on when you asked him if he had anything illegal?
Judge, that's leading, and we object.
Well, he wasn't in custody, he wasn't under arrest, he wasn't detained.
Judge, that's leading. And besides that, the officer has already said he was detained until further investigation about his muffler. So, for all practical purposes, he was detained at that point. His Miranda rights had attached at that point. He wasn't free to go.
Was Mr. Patro free to leave, or was he under arrest when you asked him the question?
He was not under arrest.
Not under arrest when you asked him if he had anything illegal in his car?
Correct.
Where did you proceed from there after asking Mr. Patro that question?
He stated there was nothing in his car.
Judge, we object. The objection has been sustained to the question, do you have anything in your car? He was not given Miranda. The court has sustained my objection to that. Then counsel comes right back and asks the same question and gets the answer. That's not proper. We object to that.
His objection, my understanding, Judge, wasn't for that question, it was with regard to custodial interrogation. That's what his last objection was to, not for the fact of whether the question was asked.
I think the question was answered, so let's move on.
What happened next, officer?
We object to the form of the question, what happened next, Judge. He should be more specific. That just allows the officer to testify in narrative form, and it may violate a previous ruling the court has made with respect to respecting this citizen's Miranda rights. So We think he ought to be more specific rather than being allowed just to testify in narrative form.
Told him that, we had had a lot of complaints with him selling marijuana.
Judge, we object, that's just rank hearsay, that was the exact reason.
Sustained.
Do next, officer, no?
Allowed him to go inside and get his insurance, where he also told me that he had a marijuana pipe that he was gonna retrieve for me.
He volunteered the information, he had a marijuana pipe in his house, he was gonna give it to you,
He did.
okay? Did you go inside the residence with him?
I followed him inside while he was retrieving the pipe.
Okay. Did he make any other statements to you while he was inside there retrieving the pipe?
Yes, said he did not sell marijuana.
What happened after he retrieved the marijuana pipe for you?
While I was waiting on him to get the marijuana pipe, I seen him in plain view, marijuana laying on the table.
Inside the residence?
Yes.
Did he ever tell you that you had no reason to be inside his residence, or
Never did.
did he invite you in to get the marijuana pipe when
Yes,
he volunteered the information about having it?
he did.
Okay. What did you do with the marijuana that you saw on the table there in plain view?
It was confiscated.
Okay. Did you later send that to the Alabama Department of Forensic Science? Did you ever receive an analysis back from the Department of Forensic Sciences on that alleged marijuana you sent?
I'm not sure that the drug investigator might look at that.
I'll show you a certificate here that I marked for identification of the city's Exhibit A. That seems to indicate that was the material.
Judge, we're going to object to the witness reading from the document, it's not in evidence yet.
You didn't read from it. Who did you turn the marijuana over to when you brought it back here?
Either Detective Matthews or Detective Curtis, I'm not sure which one.
Are they the officers that take charge of narcotics when they find them on stop? Okay. Said I would offer city's aid under the statute regarding forensic certificates.
Judge, the only
Admission.
problem with that, and the objection I have is that section 1221-301 Code of Alabama 1975 provides as follows: notice of intent to offer proof by certificate of analysis. Party seeking to introduce a certificate of analysis shall, not less than 40 days prior to the commencement of the hearing or trial, give written notice to all parties of intent to offer proof by a certificate of analysis. The notice shall include a copy of the certificate of analysis. There has not been a showing that statute has been complied with. The reason there has not been a showing is because it has not been complied with. In fact, the city to this good day does not offer a certificate of analysis in a single marijuana case that is pending today. And we object to the certificate of analysis on the grounds that the statute has not been complied with, and move that the court disallow that certificate.
Mr. Blackley received the certificate way more than 40 days ago, Your Honor. We've been discussing this case for some time now. Whether he had a copy of it or not, I'm not sure. He or his son, associates, have seen that certificate.
Well, I've never seen the certificate of analysis, and it's incumbent upon the city to prove that they gave me the certificate of analysis at least 40 days before today. That has not been done. Your Honor, it's a simple thing.
Is there, I understand you say they have seen it. Has the city provided them with a copy of the certificate of analysis?
I'm not sure. I can't say that we have.
Have you received a copy of the certificate?
No, Your Honor, I have not.
sustained.
Describe the marijuana pipe or drug paraphernalia that you found in the residence or that Mr. Patro went in to retrieve for you.
There was 2 pipes, a set of digital scales, a marijuana grinder, pack of roll papers, numerous hemostats, and a coffee jug full of seeds and stems.
These are items that he retrieved for you.
No, these are items after I located the marijuana in the desk, and he said that it was inside the desk.
So he told you they were in there.
He did.
Any of these items appear to have marijuana residue on them.
Judge, we object to the way they appeared. There's been not an adequate predicate showing how this officer could possibly testify about the appearance of something appearing to be marijuana residue.
Any appearance of a green leafy substance on any of these items.
There was green leafy substance.
You're familiar with the smell of marijuana by sight as an officer. Did it smell and appear to be marijuana to you?
It did.
Okay. This was on what items that you mentioned as far as drug paraphernalia? The pipe?
Pipes, the hemostats, the grinder.
Okay. Was there any analysis performed on those items?
I don't believe so.
Did you arrest Mr. Patro on this occasion?
Did not.
Tell us why you didn't arrest him this day.
He was offering to give information in order not to arrest him.
Did you at a later date file a complaint for these offenses and arrests?
Same day, a report was done, documenting everything that happened.
Okay. Did you sometime later, actually?
Yeah, actually, I gave him, I believe it's 2 weeks to give some information, and he didn't do so, so I wanted to sign.
So that's been maybe not clear where he lives.
I don't have that.
Judge, I believe that's all, Mr. Mayor, this time.
Cross examination.
No questions, Your Honor.
See the rest, Judge.
Your Honor, at the close of the city's case, I make a motion for a judgment of acquittal as to both the charge of possession of marijuana and as the charge of possession of paraphernalia, and assign these grounds separately and severally. Number one, as to the marijuana charge, there has been zero proof that the substance seized was in fact marijuana. As to the alleged paraphernalia, each and every item that this officer has described, whether it's something that you smoke with, surgical device or tweezers that you use for other purposes, cigarette papers that can be used for legitimate purposes, there has been no showing that these items in fact had any marijuana residue of any sort. In fact, the officer's testimony was that there was not even an analysis performed on these items. So we make a motion for a judgment of acquittal as to both counts and sign those grounds separately and severally.
Judge, as far as possession of marijuana charge, due to the life notice, Mr. Lackey, we have a non-process marijuana charge.
Judge, we object to it being non-pros because jeopardy is attached. If it's non-pros, then theoretically it could be brought again. Jeopardy is attached, and we think that the case ought to be ruled on.
Mr. Lackey, as to the possession of marijuana, your motion is granted. As to the possession of drug paraphernalia, your motion is denied.
All right.
Call your first witness.
We have no witnesses.
I take no vote.
Nothing further.
Mr. Patro, the possession of marijuana case has been dismissed. That's on the attorney's motion. Possession of paraphernalia, I do find you guilty. It's a $400 fine, $254 court costs, 10 days in the city jail. The jail sentence is suspended for a period of 12 months pending no further violations. You have 14 days from today's date to file notice of appeal to appeal this decision to the
We give notice of appeal, Your Honor.